To introduce this evening's speaker. Tonight we have with us speaking Jack Urban. He's been a Torch Club member for about the last 15 years. Jack has a PhD in chemical engineering from the University of Maryland, a new addition to the Big Ten. He worked for Upjohn here in Kalamazoo, Portage, for 30 plus years. His interests are quite diverse, include a number of areas in the liberal arts and especially American history. And he conveyed to me that he lived as early teenage years in South Carolina, and that's where he came across tonight's topic and the history behind that, which is the case of Judge Waring. And as we all know, there was not suddenly after the Civil War a an acceptance throughout the entire country of civil rights for the black population. And Judge Waring is an example of the courage that it took to correct that, which of course took quite some time. So I give you tonight Jack Urban and the courage of Judge Waring.
Yeah, I have the shield over the. Oh. Yeah. Okay. So. Something can go wrong. It will go wrong. So we're getting close. So we still need to do something else. There we go. Okay, that's the screensaver. That's something to look at when I don't want you to. Okay. That's something. Okay, now you can hear me okay? I'm going to try to put this on the other side. Maybe I'll just stick it on my necktie. Because I do want you to hear this. Okay, is that pretty okay? Okay, well, uh, why this topic interests me is that I used to live in South Carolina. The period that I lived there was in the early 1950s, 1953 to 1959. And that period coincided with a period of great unrest and consternation uh, throughout the South uh, over race issues. Because at that time in South Carolina uh, and throughout the South, the black and white school systems were entirely separate. Now, some of you may remember that. Those of you who are my age and older, at least were aware that that was going on. Um, there were no Negro students in my classes in Aiken, South Carolina, but I had moved from New Jersey, and in the sixth grade, there were black kids in my class in New Jersey. When I moved to Aiken, I learned that the state was in the midst of a massive building program to uh, uh, create within the black school system quality of schools, that, at least in terms of facilities and services, that were equivalent to white schools. It was a belated attempt to demonstrate that separate but equal was a concept that hopefully would survive court challenges and preserve segregated schools, at least in South Carolina. At that time, separate services and facilities for black people and for white people were entirely legal down there. Um, and that's according to a sequence of interpretations of the 1894 ruling of the Supreme Court known as Plessy versus Ferguson. You may remember a little bit of that from your history. And that dealt with the provision for separate railroad cars, passenger railroad cars for blacks and whites. And all of that stuff that happened after that started from there. So, uh, South Carolina, by when I arrived there, had just 2 years before instituted a 3% sales tax to pay for these new schools to match the white schools in quality uh, wherever they were needed throughout the state, which was everywhere, every school district. By the time I arrived, most of those schools had been built. But I wondered as a 13-year-old why citizens of South Carolina had to go to such expense while up north the problem had already been solved. I mean, dealt with. I mean, that's how I felt as a 13-year-old. I had no idea how backward the North was. Looking back, we all remember some of the riots that went on in Boston and all that during that period. It was not exclusively a South problem. Well, the South Carolinians that I met, most of them, uh, were quite proud of the fact that they were at least doing something to remedy the disparity in school systems. Yes, it is expensive. Yes, it's the price you must pay to maintain two separate school systems. But I thought to myself, they're still segregated. A statement I heard occasionally from the locals at my age was, well, at least we're not as bad as Mississippi. They took some pride in that. The last time Carol and I were in Charleston, I noted that the federal district courthouse there was named after a Judge J. Waties Waring. Having once lived down there, I was particularly curious about that. A federal courthouse? Who was Judge Waring? What side was he on? Remember, there are lots of statues of uh, Robert E. Lee still standing around down there too, right? So I'm going to show you a picture of a statue that a friend of mine took of there. Okay, these, by the way, these are some of the, I'll just interrupt myself here and say, these are some of the characters that I'm going to be talking about. And so just glance over that and, because these are names that I'll mention in my talk, okay? But what I want to show you next is, this is a statue of J. Waties Waring that is standing in front of the Justice Complex now in Charleston. So I did some research on this man, and I learned that Judge Waring played a pivotal role in setting up the argument that prevailed in the Supreme Court's ruling in Brown versus Board of Education. I also learned that Judge Waring had provided Thurgood Marshall with both admonishment and advice during the period that led up to the Supreme Court decision. I've gone back and forth on whether I should read this or speak it, and I'm still trying to decide. The case brought by Brown versus Board of Education was actually a consolidation of four cases. The central case of the four, Briggs versus Elliott, the one that attacked separate but equal most directly, was actually from South Carolina. Harry Briggs was the lead plaintiff, and R.W. Elliott was the uh, chairman of the local school board in a district in South Carolina known as Somerton. It's about 30 miles southeast of Columbia. I visited there. I'll talk to you about that later, maybe. So the rest of my story deals with this case and Judge Waring's involvement in it. Uh, this case, whose original purpose was to force the school district in Somerton to provide bus service for black children as it did for white children. At that point, this is early, middle, mid 1940s, uh, the black kids had to walk to school, and some of them had to swim a river to get to school. And one kid drowned trying to get to school. Uh, The case was thrown out because the plaintiff at that time lived just on the outside edge of the school district. And the attorney for the defense uh, pointed that out, and so the case was dismissed. But the case was reintroduced to the docket of the federal district court system with a broader complaint and a new set of plaintiffs. This suit addressed the unequal instructional facilities throughout South Carolina. The case, when finally heard by a three-judge panel, of which Judge Waring was a member, was a broadened iteration of the fundamental complaint, which is unequal unequal representation, whoops, unequal treatment of black and white school school children in the state. Well, how did Judge Waring, a Southern gentleman, a sixth generation member of Charleston aristocracy, find the courage to write his dissent in Briggs versus Elliott? He used the term unexampled courage, end quote, in characterizing the plaintiffs of the case. And I say it applies to him as well. There may have been people like him in South Carolina, troubled by their government's unequal treatment of its citizens, but he did something about it. What made him different? When he was appointed judge of the U.S. District Court for Eastern South Carolina, he was 62 years old. All of his involvement in the civil rights field occurred in the last 8 years of his career. The first milestone I can mention about him uh, was a case known as Duval versus the Charleston School Board. And this was a bench trial that took place in 1944. A black chemistry teacher, Viola Duval, complained that she, along with others similarly situated, was being paid 30% less than white teachers with comparable experience. Her advocate, Thurgood Marshall, then a young attorney working for the NAACP, expected from the judge the usual head whipping before he would have to carry the case on to an appeals court where hopefully the decision would be overturned. Uh, Marshall, who was just 35 years old then, was already the chief counsel for the AACP's Legal Defense Fund, which brought top grade legal expertise to civil rights cases occurring throughout the Old South. This Thurgood Marshall is the same one that was appointed Justice of the Supreme Court in 1967. That's probably not news to you, but it's important. As this trial involving the school board began, well, this, by the way, this is Judge Waring. So he's a very distinguished looking gentleman. Uh, as the trial began, Marshall, uh, Thurgood Marshall, believed that Waring was just another Southern jurist. Early on, though, Judge Waring directed a question to the attorney for the school board, asking him for the date of a related decision made 4 years earlier in the state of Virginia. Marshall knew the answer and stood up to provide it. The judge told him to sit down, saying, "I'm asking your opponent the question." The school board attorney finally found the reference in his files and said 1940. Waring then asked him the date of a still earlier decision made in a Maryland case. Again, Marshall stood up to answer it, thinking that he was being helpful. Again, the judge admonished him, more sternly this time. When the school board's lawyer announced that the Maryland case was decided in 1939, Waring turned to Marshall and said, "I knew you had the answers. I was trying to determine how long it had been that the school board of Charleston had known it must pay equal salaries." School board's attorney was shocked, and Thurgood Marshall was pretty amazed too. The school district was given 2 years to remedy the situation. Waring made an identical ruling in another equal pay dispute a few months later. Equal pay for equal work, regardless of race. These two cases worried him a good deal. He wrote, I knew the thing was coming to a showdown someday. How would he respond? When I was in South Carolina in high school, 10 years later, how did I respond? Well, I stayed seated with the other Yankees while my colleagues stood up to sing Dixie. Wish I was in the land of cotton. Old times there, not forgotten. They sure weren't. About this time, Judge Waring rather suddenly divorced his wife of 32 years and married Elizabeth Hoffman from New York, who wintered in Charleston. He had met her at bridge parties. When they first met, they both were married. But after they divorced their respective spouses and married each other in June of 1945, they were almost immediately excluded from Charleston's society circuit. Elizabeth was the granddaughter of a Michigan lumber baron, and was a lively addition to any social gathering. But neither she nor Judge Waring were invited to Charleston parties anymore. At the time of their marriage, he was 62 years old and she was 50. What caused them to make such a big change so late in their lives? Well, I'll speculate that Waties' first wife was entirely comfortable with the Southern way of doing things and didn't like to talk about matters of law. Although Waring's new wife was uncritical of Jim Crow practices, basically the Southern way of life, uh, as a Northerner, she was under no obligation to defend those practices. I imagine that she was someone with whom Waring could talk, could test his thoughts with, and be pretty sure that their conversations would remain private. Still, in 1945, Judge Waring wasn't very far along in his conversion. The whole country wasn't, actually. Black soldiers on leave, returning from where they had been risking their lives during World War II, for example, sparked Detroit's first race riot at the Packard assembly plant in 1943. As more black servicemen returned home to stay after the war, the resentment resulting from Negro veterans' growing self-confidence and decreasing deference to white authority was a source of racial friction. This was especially true in the South, where lynchings and other sorts of violence became common. Down there, the police were no help, and out of uniform, they were part of the problem. The courts offered no relief at the state level, and the U.S. Justice Department, whoops, backed up here, not quite ready for that yet. Um, the U.S. Justice Department, um, I would say, lacked zeal in those days. It came, though, under increasing pressure from the NAACP and from black owned newspapers throughout the nation to hold violent racial offenders accountable. The pivotal case for Judge Waring and his conversion from a Southern gentleman that fitted in with everybody in Charleston occurred in November of 1946. In February of that year, a Negro Army vet, Sergeant Isaac Woodard, was traveling home by bus, having just been discharged from Camp Gordon in Augusta, Georgia. Now I'm going to update these slides just a little bit here. This is a picture of young Thurgood Marshall. And so that's as far as I'll go for now. Okay, so catch up now. Um, okay, they were traveling on a bus, uh, and the bus was filled mostly with returning vets, both white and black. They were probably passing a bottle around and exhibiting a lot of conviviality. The war was over and they were going home. Many were still in uniform, as was Isaac. Also on the bus was an elderly white couple who complained to the driver about the noise and the language. I imagine that when the driver refused to make a rest stop for Isaac, he said something like, "Listen here, boy." Isaac replied, "I'm a man, just like you." That got him put off the bus in Batesburg, South Carolina. There, the town police chief attempted to arrest him at the behest of the bus driver. There was a scuffle, and it ended with Woodard's being blinded in both eyes with the handle of the officer's blackjack and being arrested. The NAACP learned of this incident while Woodard was still in the VA hospital in Columbia. And because this was similar to so many other incidents in the South at that time, the NAACP encouraged the public to help them identify Woodard's assailant. They even fed this story to Orson Welles, who had a nationally syndicated radio program at the time. Welles used his flair for drama to make a national appeal. Who blinded Isaac Woodard? It worked. The policeman's name was found to be Linwood Shull. The pressure from the black community for federal the federal government to get involved became unrelenting. President Truman, after getting an earful from the NAACP leadership, pushed his attorney general to take action on a Woodard case immediately. That was in September of 1946. However, neither the Justice Department nor the FBI were eager to jump on it. Claude Sapp, a fellow who was on that list of people there, who was a senior U.S. attorney assigned to prosecute uh, Officer Shull, attempted to delay the trial until after the November 5th election in 1946. Um, Sometime before the trial, Sapp met with Judge Waring in his chambers. There, he informed the judge that he planned to ask for a continuance. And if the evidence turned out to be insufficient, he might even ask for dismissal of the case entirely. That put Waring on guard. He was annoyed that at what seemed to him to be a political expedient. The judge told Sapp, quote, either you bring the case on the date already set, that is Monday, November 4th, the day before the election, or I'll dismiss it and I'll tell everybody why, that you weren't prepared. The trial of Linwood Shell for assaulting and blinding Sergeant Isaac Woodard, a Negro veteran still in uniform, began as scheduled on November 4th. Elizabeth Waring was present in the courtroom. That turns out to be significant. At the start of the jury selection from an all white panel, Policeman Shull's attorney requested that the judge inquire if any prospective member of the jury belonged to the NAACP. The attorney for the prosecution did not ask the corresponding question, was anyone a member of the Ku Klux Klan? So right away, anyone could see how this was going to go. Shull's attorney attempted to establish that Woodard had been drinking on the bus and had used profanity in a verbal exchange with the driver, as if Woodard was on trial for misbehavior. This was done with the intent of showing the jury that Woodard deserved to be arrested when he was put off the bus. So you have to kind of go back in time to imagine what things were like then. You know, this is kind of a deep dive into our past. but still in our lifetimes. Well, in the trial, Woodard was led to the stand and testified that yes, he had cursed at the bus driver and had said, "I'm a man just the same as you." Woodard then related how he came to be blinded. After Woodard was popped on the head with a blackjack and arrested, Officer Shaw led him around the corner out of sight of witnesses. There, a scuffle ensued, and Woodard was temporarily able to get control of the blackjack. When Shaw regained control of the blackjack, he stabbed Woodard in the eyes repeatedly with its handle. The other end of the blackjack is too big to fit in the eye socket. After spending the night in jail without medical attention, Woodard was taken to court and fined for a misdemeanor. He was then transported to a nearby VA hospital where word got out about what had happened to him. Well, at the trial, you can kind of start to sense the prosecution's conduct was sloppy, to say the least. Testimony of the bus driver and the other officer present was taken. However, none was taken from the passengers on the bus who had been subpoenaed and were present in the courtroom. The prosecution failed to follow up on conflicts between oral testimony given at that point and earlier written testimony. Finally, at the summation stage of the trial, the defense attorney asked for a verdict of innocent, and the prosecuting attorney, Mr. Rogers, uh, asked the jury to find Officer Shaw guilty. Well, that's to be expected. Then, though, U.S. Attorney Claude Sapp, Rogers' boss, asked Judge Waring if he could address the jury as well. The request was granted, and Sapp told the jury members that he had fulfilled his duty by bringing the case to them and concluded, quote, "Whatever verdict you gentlemen bring in, the government will be satisfied with." Now, that was a wink and a nod to the jury as if they needed one. The jury retired. Waring told his bailiff, "I'm going for a walk. I'll be back in 20 minutes." The bailiff said, "But they'll have a verdict in 5 minutes." The judge replied, "They'll take 20 minutes because they can't leave the room until I get back." The verdict, though thus delayed, was not surprising. Elizabeth Waring, who had been sitting in the back of the courtroom, was seen leaving the room in tears. In addition to what I've just told you, she had also heard the defense attorneys in their summary announce that the people of South Carolina resented this federal civil rights prosecution, arguing that, quote, "if a decision against the government means seceding, well, then let South Carolina secede again." A dreadful, as Judge Waring would later relate. One of Shull's attorneys argued that a guilty verdict could leave law enforcement officers powerless to protect the public. That triggered a reminder from the judge that law enforcement wasn't on trial, Linwood Shull was. More in that vein, the defense further argued that Woodard's admission that he had talked back to the bus driver demonstrated that he was intoxicated because, quote, "that's not the talk of a sober Negro in South Carolina." I hope you're getting a pretty big bellyful of what it's like down there then. No wonder Mrs. Waring was upset. I think you would have been too. For starters, no attempt was made to reconcile being blinded in both eyes with the assertion that it was caused by a single blow to the head. The abysmal performance of the federal government's prosecutors, the outrageous threats made by the defense attorneys, and the fact that the FBI agent on the case refused to sit at the prosecutor's table uh, really rocked the Warings both. both of them. Elizabeth, having come from a privileged northern background, told her husband that she had never before heard or seen such a terrible thing. Privately, she shared her distress with a friend, a native South Carolinian, a few days later. The friend responded, "That sort of thing happens all the time. What are we going to do about it?" Well, that's a rhetorical question, but it put both Warings on a course of reflection and study that transformed the path of their lives and the course of civil rights history in the mid 20th century. They began by reading and discussing two books. One was The Mind of the South, a mass psychoanalysis of the white South by a reporter for the Charlotte Observer. The second book was Gunnar Myrdal's book, The American Dilemma. Maybe some of you were aware of that from college. Judge Waring and Elizabeth would read a chapter at a time aloud to each other over dinner each evening, and then go for a drive and discuss it in the privacy of their car. They made a point of getting to know civil rights leaders in Charleston, and in time, many of them became close friends, and they often shared meals together. So here's a photograph of Isaac Woodard after he was blinded. Here he is with his mother. And here's a picture of the Warings entertaining in their home the leaders of this NACP in the Charleston area. So you can see that there's a gap between the rest of the whoops. There's a gap between the rest of the Southerners down there and the Warings. Okay, I'm going to leave this there for now. By 1948, Judge Waring was actively examining his docket for upcoming civil rights cases so he could prepare for them. Already, his decisions had ended some discriminatory voter qualification practices in the state. Growing impatient with Southern intransigence, he warned, "Next time there will be no fines," meaning that if there was a civil rights infraction that someone was convicted on in his court, that person would probably go to prison. It's a big step. In the searches of his docket, uh, Judge Waring found a case that would eventually come to him, a suit brought by the parents of black children in that Summerton, South Carolina school district I talked about earlier. The conditions in the Negro schools there were deplorable. No functioning indoor restrooms, few blackboards, only $1,800 spent on school equipment per year versus an average of $12,000 per year in the white schools in the same district. No fenced-in schoolyard, and on and on. The suit was aimed at proving that the facilities for white kids and for black kids were not equal. It was pretty obvious that the facilities are unequal and were becoming indispensable. Robert Figg, a formidable Charleston attorney, proposed that the state legislature undertake a massive program to build new segregated schools for the Negro community and equip them so well that they could pass inspection for being equal. The new governor of the state, James F. Burns, endorsed this proposal in his inaugural address, and his popularity among the voters was sufficient to get a reluctant legislature to go along with it. A legal decision on the acceptability of the separate but equal concept would be forthcoming when Briggs versus Elliott was decided in court. Judge Waring was also aware that this case would be pivotal. In a routine meeting with Thurgood Marshall to discuss the case, as it was then formulated, the judge told Marshall, "Don't bring me another separate but equal case. Go after the separation itself directly." Marshall resisted at first, preferring to use the so far successful step by step method. But after consulting with the more militant members of the NAACP, Marshall agreed to withdraw the suit and reformulate it in such a way as to claim that separate in itself is unequal. The NAACP team had to go back to the plaintiffs and explain that the stakes were much higher now. Are they still willing to participate? 20 new plaintiffs were found, ready to take the risks, the opprobrium, the loss of jobs, or even life that this commitment might entail. Waring's strategy turned out to be brilliant. He knew he would hear the case as a member of a three-judge panel that is convened to rule on constitutional questions. With that in place, as long as the panel's decision was not unanimous, it could be appealed directly to the U.S. Supreme Court. It was sure not to be unanimous with Waring on the panel because there were not two other judges in all of the South who would be willing to apply the 14th Amendment of equal protection to the laws to this case. So now we have two trains heading for the station on the same track. There's going to be a collision. The hearing before that three-judge panel took place on May 28, 1951, in Charleston. Thousands of black folk from all walks of life came to town, filled the courtroom and the streets outside of it. They'd been anticipating this point for over 3 years, and the outcome was by no means certain. The trial got off to a rocky start for Thurgood Marshall and the NAACP because Bob Figg, the lead attorney for the state of South Carolina, conceded at the outset that the school systems in that state are unequal and announced that the legislature had just approved a $750 million bond issue to finance the construction of new facilities for black children throughout the state. This surprise announcement was intended to render the NAACP's lawsuit moot, as the state was admitting guilt and intended to atone for it. All it needed from the judge, the three judges in the panel, was a stay of proceedings for a couple of years to give the state time to implement the remedy that they had proposed. Equal but separate schools. The NAACP's attorneys, led by Thurgood Marshall, were thrown off at first by this, but they quickly recovered. They pointed out that their suit rested on the contention that school segregation in itself is unequal and asked the judges to proceed with a hearing as scheduled. So it's quite a big shift, all in the state of just a few minutes at the beginning of this trial. With the school board's concession of unequal facilities, much of the evidence that the NAACP planned to offer was no longer needed. The discussion turned to the question, can separate schools ever be equal? Here's where it gets really interesting. Thurgood Marshall introduces his star witness, Dr. Kenneth Clark, who, with his wife, had published the results of surveys using as an instrument two dolls, identical in every respect except skin color. Respondents, adults and children, were asked, with which doll do you associate positive qualities such as honesty and dependability, and with which do you associate lack of initiative and untrustworthiness? The results were, as you would expect, from around the country. The white doll was associated with positive attributes, and the black doll was associated with negative ones. But Thurgood Marshall, long experienced with Southern intransigence, felt that may not be enough. A week before the trial, he paid Dr. Clark and his wife to go to Summerton, South Carolina, and conduct their survey right there with the adults and children in that school district. Not surprisingly, identical results were obtained. Attorney Fig objected, asserting that the survey was unauthorized by the school district. You think they would authorize that? And was kept secret from him and state officials. So, what happened next? After a month of deliberation, the panel ruled 2-1 in favor of the state, reminding one and all that Plessy versus Ferguson still remained the law of the land, but also ordering that the state carry out its intention to remedy the inequality of facilities. However, Judge Waring issued a blistering dissent. He claimed that separate can never be equal. He stated that Clark's studies clearly showed that, quote, the humiliation and disgrace of being set aside and segregated as unfit to associate with others of a different color had an evil effect on the mental processes of our young, end quote. Based on this evidence, Waring concluded that it was clearly apparent that segregation in education can never produce equality, and it is an evil that must be eradicated. The system of education as adopted and practiced in the state of South Carolina must go and must go now. Segregation in itself is inequality. Because of Judge Waring's dissent, the NACP was able to appeal the decision right to the Supreme Court, as I said. It was combined with 3 other cases entitled Brown versus Board of Education. There's a little side story about how the name got to be that. The Figs, the Briggs versus Elliott case was a major component of the whole presentation, but it was not the lead case for mainly political and PR reasons, which I can explain to you later. Because the most emphatically stated arguments that were in the appeal came from the Briggs versus Elliott case. This story struck a chord with me because I was living in South Carolina then. There was hope and anxiety at first, while Brown versus Board of Education was before the Supreme Court. It took over a year for them to decide this. In May 1954, in my 7th grade year, the ruling came down. Anxiety turned to dread until the phrase, with all deliberate speed, was noted. Then folks down there breathed a sigh of relief. Deliberate speed, maybe taking forever would be okay. My high school was integrated finally in the 1970s down there. I was a silent observer. I noted how nobody ever put on a ghost costume or any costume at Halloween down there during those times. I noted the offhand language the white folk used to reinforce their casual assumption of superiority. I sensed the silent tension in the air that prevailed for weeks after the lynching of Emmett Till in 1956. People I would meet downtown, the owner of the sporting goods store, a druggist, a filling station attendant, were they capable of lynching someone? An elderly member of our church, with pride in her voice, told our Sunday school class that yes, she felt that she was a member of the elect. That is, according to Presbyterian doctrine at the time, God had preordained that they would go directly to heaven when they died. Though all of us Yankees in the class would bet that neither one of them had ever lifted a finger to remove the stain of slavery from the state. What did I do? I noted the hypocrisy of my whole church, but kept silent. As Thomas Jefferson once wrote about slavery 200 years ago, and I'm applying it now to race relations in the 1950s, we have the wolf by the ear. We dare not hold on to him, and we dare not let him go. our race problem is still with us today, and it's entrenched as it ever was, in my opinion. It's just subtler. For example, fear of crime has a racial undercurrent. Drug policy has a racial undercurrent. Agricultural policy has a racial undercurrent. Housing policy and admission policies also have a racial undercurrent. That's it. Only thing I can the only thing I can add is telling you a little bit about what it looks like in Summerton, South Carolina now. And I'm just going to just briefly skip ahead here. Uh, this is the public high school uh, in Summerton, South Carolina now. It's an imposing building. It has a beautiful green lawn all around it, and it's 94% black. It's another view of the same school. Here's a view of the elementary school, also a two-story building. And here is uh, the headquarters of the uh, school for the white kids. It's a private school. And here's another one that's an elementary school. It's in a house in downtown. So there's irony there, aplenty. So I just wanted to let you see the whole picture there. That's what happened there. Yeah, I did. Oh no, I didn't. I just the one of them in the at dinner. I didn't show that one. Ah. Okay, well, let me just whip back if you don't mind. Let's see if I can get it back fast. There. Okay, see, Judge Waring is at the far end there, and okay, so Judge Waring is the guy in the three-piece suit in the back, and the lady with her back to you, nearest us, is his wife. And those are the people who are the civil rights leaders who are having dinner at the Warings home during this period. So you can imagine there are not going to be many other white Charlestonians anywhere close to this place. In fact, U.S. Marshals had to guard their home during this time. There were bricks thrown through the windows. You know, it was not pleasant. So there you have it. If there are questions, I can entertain them now or later. But that's an earful, I know. Yes,
But then the courthouse got named after him.
yes, yes. Subsequently, many years later.
That
Uh,
sounds to me that might have been a struggle too.
well, I'm not aware of how the details of that. It probably happened during a Democratic administration when there was somebody in the state who was at least willing to acknowledge that there are black voters that needed to be attended to in terms of attention. And so I sat in his judge's seat when I was down there getting those pictures of the Somerset School District. I went down to Charleston, managed to get into the courthouse and be led into his courtroom. I sat in Judge Waring's chair. Then I went up to Columbia, where the trial of Linwood Shull took place. See, he was a visiting judge there because the judge for the western part of South Carolina wanted nothing to do with that case. So he said, Waring, you take it. So Waring did. And so there I sat in the back of the room in a chair that could have been a chair that Elizabeth Waring sat in. So it was kind of something. And back then there was no air conditioning, and so you could see where all the fans had been located on shelves near the ceiling, and there was a bit of taking me back there with that period in the 50s before public air conditioning. Yes.
I was wondering if in the schools of South Carolina or elsewhere, um, this story is at least in part told because it's important.
Well,
Because that's a pivotal point, separate but equal
yeah.
versus.
I have a feeling it's being taught in shortened form, in very concise language, as a kind of like a matter of fact. Let's get through this as quick as we can, because the people aren't going to lie down there, but they're sure not going to tell the whole truth. You know, why make yourself look bad if you're a white person down there? You know. Uh, uh, it's this discussion though is in a recent South Carolina history book that I managed to purchase. I read the section, I marked it in the book, and it does talk about Judge Waring and Robert Figg and all these people, and the facts are there, pretty much as I've told you here. But it's the drama is, of course, squeezed out of the language that goes in a South Carolina history textbook. Yes.
Jack, I wonder if you'd like to comment on the fact that in many places in the United States, from elementary school through higher education, there's a lot of uh, re- self-segregation. Blacks feeling more comfortable among themselves,
Yeah.
and so, so the integration, unfortunately, is the law of the land,
Yeah.
but not what's really experienced.
Yes. Uh, well, you can lead a horse to water, but you can't make him drink. Um, I think what I can't imagine this country surviving without a revolution by now if they hadn't eliminated the legal, officially sanctioned separation of school systems for blacks and whites. That had to come to an end. Now, how it's played out since then, I think, as we've kind of started to sense, many people now look back at that time and think that we were pretty naive. Uh, so we have a long way to go yet. Uh, in this country, even Alexis de Tocqueville pointed out that in when he wrote Democracy in America in the 1830s or so, that uh, as healthy and as prosperous and as full of goodwill as America seemed to be back in those days, uh, there was nothing in the Constitution or the state and federal laws that really guaranteed that goodwill would continue. It depended on people's basically good decency. Well, now we've seen what happens if some of that's stripped away. The Constitution doesn't protect us very much, in terms of what people can get away with uh, and still not go to jail. And it's always going to be that way. You can't put everybody in jail because they look at you cross-eyed. It's not going to happen. But in a democracy, we have to be tolerant. We have to tolerant. Even there, I think, is a really loaded word because every time I hear the word tolerant, I think of, oh, I'll tolerate it. You know, that's not a good word. You know, acceptance and respect. What I think Americans basically deserve to give each other. We have a way to go there, but to depend on the Constitution or to depend on laws to solve all that is not going to happen. So I'm kind of feeling like giving you a dose of reality here. If you haven't already gotten one, I imagine you already have, and I'm just reinforcing it. Yeah. Yeah.
document. And basically what Tocqueville said was that the United States would never permit a racially integrated country because there were blacks and whites, and everybody knew who was white and who was black. And I think people, this doesn't get taught,
Yeah.
it seems to me.
And when I was required to read Democracy in America when I was in college, it was presented as a as a piece of great optimism about the country. But if you read it carefully again now, you'll see that he had his eyes pretty wide open. So that's it for now, I guess, huh? Sure, sure. Uh, Here, if anybody wants review the names of the